We need to start with, in effect, you introducing yourself to the first year class here and talking a little bit about the arc of your career and the various kinds of things that you have done, and then we'll have a chance to get into what you liked about them and didn't like about them as we go on.
Well, good morning. As Professor Longan said, my name is Brian Jarrard, and I'm a lawyer here in Macon. I started my law practice, or practicing law, in 2000. I went to the University of Georgia and came to Macon during law school to clerk with Jones, Cork, and Miller here. So both summers during law school, I clerked with Jones, Cork, and then graduated in 2000 and began my legal career as an associate at Jones, Cork, and Miller. I was with Jones, Cork, and Miller from 2000 to 2007 when I left to, I guess, assist opening the Federal Defender's Office for the Middle District of Georgia. Many of you may or may not know, but federal indigent criminal defense in the Middle District of Georgia was done on a panel basis until 2007 when a federal public defender's office was opened. So in 2007 I left Jones, Cork, and Miller to, again, assist opening the federal public defender's office. I stayed there from 2007 to 2009. The largest portion of that time acting as interim federal defender, and then in 2009 I actually had the option, thankfully, to go back to Jones, Cork, and Miller, where I was from 2009 until October of 2012, when I did, quite frankly, what I think in hindsight I always wanted to do, and I left Jones, Cork, and Miller a second time to open my own law practice here in Macon. And my law practice now, primarily, it's a wide variety, but primarily it consists of criminal defense, plaintiff's personal injury, contested probate litigation, and business litigation. That's primarily what I do.
Now, for the students who don't know, Jones, Cork, and Miller is or was, maybe still is, the largest firm in Macon.
It usually is almost the largest firm. I mean, there are several large firms, Martin Snow, Sell and Melton, that are comparable in size, but Martin Snow is one of the oldest, if not the oldest, and I mean Jones Cork is one of the oldest. But
not large by Atlanta standards. I mean, how many lawyers are we talking about?
We're talking probably 25 lawyers.
Okay. Talk a little bit about what it was like to be a new associate in a big, quote-unquote, Macon law firm. What was that like? Because, of course, they'll be associates before they're partners. So let's talk about that life that awaits them in their more immediate future.
Well, I think being an associate at any firm, now you're certainly going to have different environments depending on the firm that you choose. But you know, quite frankly, as an associate, you're going to do the task you're assigned. I doubt most of you will have an area that you may have an area you're interested in, but your work will probably be driven by, you know, the work of the firm, what the firm does. And you know, Jones, Cork, and Miller does lots of things, but they have historically been an insurance defense firm. So as a young associate, I handled insurance defense cases, which is good experience. It's a great experience because it gives you early contact with clients, and it gives you a wide variety of things. What may be different at Jones Cork, fairly early on, we had the ability to, the young associates, to get out and do depositions and have significant client contact. And now, I've never been, you know, an associate in a large Atlanta law firm, but talking with my contemporaries, you know, I think that I was able, in a larger firm in a smaller city, to have that exposure earlier than some of my Atlanta colleagues.
Well, the students don't know this, but in about, I guess it's 2 weeks from today, we're going to have a panel of associates, recent Mercer graduates who are associates at big Atlanta law firms, and they're going to talk about that particular kind of life. But while we're on this you're early in your career here, and one of the things we've talked about over the course of the semester quite a bit is mentors, and the importance of having a mentor to help guide you through those early years. Because law school can't do nearly everything you need, right?
That's correct.
All right. We don't take that personally. It's okay to say that. Could you talk a little bit about the folks who were your mentors and,
Sure.
and how they did it? how important it was to you.
I've been very fortunate to have great mentors, and you're right. I mean, law school teaches you lots of things, but law school primarily, in my opinion, teaches you to think like a lawyer and analyze like a lawyer, but you're going to really learn to practice law when you get out there and you're working with good lawyers, and quite frankly, when you work with bad lawyers, you're going to learn what law practice is.
There are bad lawyers?
There are.
Sorry to hear that.
There are difficult lawyers. They're bad lawyers.
That they know about.
Yeah.
They've heard about the difficult lawyers.
But I was very fortunate to have formalized mentors at the firm as well as de facto mentors. And you'll find that in your practices. I mean, you're going to have individuals. I mean, you may join a firm where there is no formal mentoring program. At Jones, Cork and Miller, there is a formal mentoring program, and so as soon as I began as an associate, I had 2 older lawyers, more experienced lawyers appointed to be my mentors. Now, what happened, quite frankly, depending on the things I was doing, I kind of developed into having other mentors who became my mentors, in fact. But those, they were mentors in the sense of telling me and helping me know, if you were faced with a particular task, the nuts and bolts of what you ought to be doing, but also mentors that would encourage you and say, look, I know you feel probably much like all of you in first year law school, you're trying to figure out the language, you're trying to figure out what it is that we lawyers do, and you'll do that in practice, and quite frankly, you'll do that continually, I think, in your practice. But I had mentors who were there to say, hey, you're doing a great job, and why don't you try doing this? Or, mentors that said, look, it looks like you really enjoy this type of practice. Jones, Cork and Miller had not traditionally had a criminal defense practice, but I was fortunate to have a mentor who knew that really interested me and encouraged me to, develop that. So, you're going to find those people. If you don't, you need to seek them out. I mean, you need to have, quite frankly, I think, throughout your practice. I still have mentors. And the way your mentors may change, but you still, if it's not mentors, you're going to have a network of people who you can call upon, particularly in a solo practice.
Yeah.
And then you're going.
Okay. Why do you think older lawyers do that? Why do they take time to mentor younger lawyers? It's a tradition in the legal profession, but
Yeah.
why? What do they get out of it?
Well, one, I think many lawyers remember what it was like to be a young lawyer, and remember that law school didn't prepare you for everything you're going to encounter in practice. So, one, I think it's a sense of, I was there, someone helped me along, they had great mentors, and feel an obligation to pay it forward, so to speak. But I think that's built in our profession. I mean, we're fundamentally, done right, a service profession, and I think you're all no doubt driven, smart people, but I suspect many of you probably have a service mentality too. And 98% of the lawyers I've ever dealt with have that service mentality, and I think it leads to mentoring. I mean,
Well, and of course there are pressures on that mentoring tradition, but I'm glad to hear you describe it the way you do, because I think for the students to hear about how important it is, they need to have some reassurance that it's still alive and well, and I think it is, and exactly for the reason that you identified. Well, talk a little bit about the transition from law firm life to setting up the federal defender's office. They spent last week talking about representing unpopular clients, criminal defendants, and if they were appointed, could they do it, and so on. You seem to really relish this, and so then you made this move to the federal defender's office. Talk a little bit about that.
I did, and probably the way to start is to tell you a little bit about my history in law practice as it relates to indigent criminal defense. And when I became a member of the Macon Bar, which is not what any of you who become a member of the Macon Bar will necessarily encounter, but for the first 5 years you were a member of the bar, you were required, strongly encouraged to take state-appointed indigent criminal cases as a rite of passage, and again, as part of the service mentality of being a lawyer. The judges here thought that was important. So when I became a lawyer in 2000, I started taking state-appointed indigent criminal cases. And quite frankly, for me, it was just a personal interest that developed. If you had asked me in law school, particularly as a first-year law student, I doubt, in hindsight, I would have told you that I thought I would ever be doing criminal defense work. So we took state-appointed cases, and I just really enjoyed. I thought it was very fulfilling work. I thought it was, it really made you feel like a lawyer. You were representing some of the poorest, some of the most indefensible, in many cases, individuals, but folks who, absent your representation, just were not going to have a voice. And I always thought it was pretty cool to be a lawyer and then a partner at Jones, Cork and Miller and see very poor individuals who they would, by and large, not have any access to that old firm, that level of expertise, that network of lawyers. So, so it was really a natural outgrowth for me, having been in civil practice. Quite frankly, none of you know, Tim and Daisy Floyd are my relatives. I am married to their niece, and
that was a secret.
In 2007, I learned of the opening of the Federal Defender's Office, and quite frankly, at that point, it was a natural fit for me, given my developed interest in criminal defense work. So it was an easy decision for me at some levels. Now, in all candor, having left a partnership at an old firm and with a certain level of respect, personally and as a member of that firm, there was a time when I first became a federal public defender that I did scratch my head and go, what in the world have I done? This is a much different world than I was used to.
Why? Was it because the lawyers looked at you differently, or
there was some of that.
Resources that available to you?
It was probably just a realization that this is a huge shift in the focus of what your career is, the focus of what your career may be, and it was less important to me personally, but there was certainly some of that. Other lawyers saying, in the world, you left a good law practice where you were, on the rise and doing well to represent indigent criminal defendants. But you're going to deal with that. You'll have individuals who it's just incomprehensible as to why you would do that. That may be some of what you all talked about with Charlie last week. But the fulfilling nature of the work was always there, and that's what was so cool about it, and why I continue to do criminal defense work, because it's just exhilarating. Everything I do is litigation, and I'm a litigator to the core, and it's exhilarating to stand between the awesome power of the government and an individual. That's for me personally, is a very fulfilling thing to do.
At what point did you know you wanted to litigate? I always tell students that's the first big decision as you think about a career path, is I'm going to litigate or I'm not. There's not that many people that dabble in litigation. So when did you know that? When you're 12 or
no, in fact,
law school?
Had you asked me at 12, I would have never thought I would be a lawyer. I did know in law school that I wanted to be a litigator. There's no question about it. That's my personality. I'm very competitive, and but I think I have a healthy perspective on being competitive. But litigation, I was very involved in mock trial and moot court in law school, and so I knew in law school that I'd be a litigator, that transactional, not to, nothing negative about transactional work, but that's just what I'm cut out to do.
Well, you, after a time back at Jones Cork, you last October opened your own firm.
Right.
That was a brave thing to do, I think. Tell us about that decision. You go back, you're a partner in this firm that's been around well over 100 years,
right?
And you decide to strike out on your own. Why?
Well, one, because I knew at that point I was 12 years into my legal career, and some of it were practical considerations, quite frankly, and some of it was just, for me, I felt it was an important time in my life to chart the course for what I was going to do long term. One, I did want more autonomy. in the decisions about what cases I handled, how I was going to practice law. But there was some anxiety involved, and no question about it. I mean, we can talk about, I have a large family.
Yeah, we're going to talk about
but you know, and my wife and I kind of jokingly said, you know, in September, October of last year, when we were contemplating together this decision, that, you know, we said both when we were contemplating it and after we did you really, are you contemplating, or did you just leave, you know, one of Macon's oldest, most established law firm with a very large family just to strike out on your own? And we did. But it's been the most wonderful thing I've done, truthfully, in legal practice, because again, you know, I talked about the fulfillment of doing criminal defense work. It's also very fulfilling to make your own way, and to, you know, I was fortunate because I did have somewhat of, you know, I had developed my professional reputation, as I continue to do. I mean, it's not developed for all time, but
as they're developing theirs.
Right, absolutely. But I mean, I was in the Macon bar, and I had individuals who knew my interest in the things I had been able to do in law practice. So, and a practical side of this was I also had, when I left the firm, I left certain clients that were, quote, my clients. When you leave a civil practice to go into federal criminal defense, as you can imagine, you don't take the civil clients with you. But I had gone back and redeveloped those relationships. So on the practical side, I could leave and have certain clients that were going to come with me. And I mean, that's the business side. But some other realities were the nature of the practice that I had developed, even in the short time being back at Jones, Cork & Miller, doing criminal defense work, doing personal injury work. Those were things that traditionally had not been that firm's focus.
You mean personal injury on the plaintiff's side?
Right,
Yeah.
right. Okay. So it was, part of it was just a natural outgrowth of where my practice had taken me.
All right. Well, it's March. You've been at this, what, 6 months? Do you have a typical day? I bet you don't. But
I have what I plan to be a typical.
All right. Well, do your best. Tell us what a typical day is like for a solo practitioner in Macon.
Well, I'll tell you, it's typical in that it's not typical. I plan every day to have certain things accomplished and certain files to get to. Invariably, I never get to that list of clients. Now, sometimes you have to just carve out, and I'll tell my assistant, you know, you need to take messages. I've got to get this brief out, or I've got to get these individuals contacted. I've got to get the question answered. But you know, I would say one thing about practicing in Macon, at least for me, is I do value my family time. So my typical day, if it is, are 8:30 to 5:30 or 6. But oftentimes I will also take files home at night and work for an hour, hour and a half in the evenings when the children are situated, or sometimes when they're not. But
or at least some substantial percentage of your children.
Right.
Brian has 6 children, so we just get that on the table right now.
So that's right.
You all are playing a zone defense now, right? There's no man-to-man anymore.
Few times. That's exactly right. When you're outnumbered, you're outnumbered. So, but oftentimes, you know, I'll work in the evenings, but not in any way that I think interferes with my family time. So.
Well, you took some clients with you from Jones Cork, but where do your clients come from? I mean, we've stumbled across in the course of it, you know, some discussion. Actually, it was with Lamar Sizemore. He brought up the question of advertising, and of course, Lamar is a generation ahead of you, and he didn't care for advertising. And so, but that's why it's on my mind. I mean, where do your clients come from?
Well, you know, I knew I would have to figure that out as I went along, and particularly in a solo practice, but I've been very fortunate. I've done no advertising since I launched my new practice, and everything I've gotten has come from referrals from other lawyers.
No advertising?
No advertising whatsoever. In fact, and I wouldn't recommend that at this stage, and I will get to advertising. I'm not opposed. Well, I will get to a certain level of making sure my contact information and name is in the public eye. I don't know that I'll advertise in certain senses, billboards, and nothing against those, but billboards or commercials. As long as my practice continues to go the way it does without those things, I doubt I'll go that far in advertising. One of that's practical consideration of cost and overhead. As a solo guy, I've got enough to do now without doing those things. So why generate, that additional level of potential client contact, potential client obligations? But other lawyers, former clients, friends of former clients. It's interesting because I had a lawyer friend of mine tell me right before I opened my own practice that he said, it's interesting, you'll see that criminal defense and plaintiff's personal injury, those actually they're helpful to one another. You help a family member out, you're going to get referrals. And this particular lawyer was saying, look, I don't do any advertising, and now it's just generational. Folks I've helped in the past send their family to me. So, I'm obviously honored to have other lawyers send work to me. And some of that's a product of what other lawyers don't want to do. The retained criminal defense work I do, in large part, is a product of lawyers who choose not to do criminal defense for all the reasons why folks choose not to do criminal defense.
Yeah, somebody will know them and call them, and they'll say, I don't do that, but let me put you in touch with my friend Brian.
Right. And it's a two-way street. There are things that I either don't know how to do or choose not to do, and I'm very conscious of sending those individuals to folks who are going to do them a good job and who refer business back and forth. That's part of the business of law.
A couple of times now you've mentioned terms like overhead and cost and things that are really business related. And you're practicing law. You're a service profession. At the same time, you're really a small businessman. Sure. Running your own small business. What prepared you for the business side? And what do you think of the business side of all this?
Well, yeah, being a good lawyer does not mean you're a good businessman.
No, it's not.
But one great thing about being a lawyer, particularly if you choose to strike out on a small firm or a solo firm, is you're the economic engine of the firm. So unlike many professions that would have a lot of overhead, being a lawyer, particularly being a lawyer in a solo firm, does not have to be heavy on the overhead. And that's one reason I approached my practice the way I did. I went in with another lawyer, we office share, we split overhead. And I've had several lawyers in my short tenure already having my own practice who've asked me the same thing, is, when I'm thinking about hanging my shingle. I do think one good business strategy is you need to be aware, you need to be very conservative on your overhead early. And then, quite frankly, your overhead can, you can spend more and more on overhead depending on what you want your law firm to look like, what you want, whether you want to buy a building, whether you want to build a building, whether you want to have complicated computer networks.
Or have a booth at Starbucks with a laptop and a cell phone.
Absolutely. Somebody asked me that just recently, but do you even have to have an office? I don't think you do. I think it's still a people business, though, and you're going to have places where you can meet with individuals, about their case, but that doesn't mean you have to have an office. You can have access to a suite of conference rooms. So.
Do you want to grow? Do you want to hire other lawyers? And if you do, I'm sure some students will come talk to you. But do you envision this as a firm, or you envision staying solo as the years go on?
I probably will stay solo. And part of that's my experience, and part of it is, one practical consideration for me in leaving the big firm was the practice areas I had. And I don't mean this critically to the associates, but the associates that were being driven to the big firm were not interested in the types of practice that I was interested in. So as one of the business decisions I made was, I'm a partner here and I'm carrying the overhead. Like a partner in any firm, you're carrying a percentage of the overhead, and quite frankly, overhead includes associates. And I was able to say, well, this is the work I'm doing, but I'm not really needing or drawing on this stable of associates, so that's not something I needed for my practice. Might I get to the point where I bring on an associate? Maybe. But right now, I'm quite frankly enjoying the autonomy of, you know, I know what my AR looks like, I know what my overhead is, and I do feel some obligation to, you know, if you bring on a younger lawyer, and you can mentor a younger lawyer, but if you bring a younger lawyer on as an associate, then, you know, that individual expects and deserves a paycheck, and, you know, that's an obligation, you know.
Well,
not that that couldn't happen, but.
Well, with that business plan, you better not advertise on TV with music and rap songs.
Right.
You generate too much for you to do. One of the phenomena we see with this generation of new lawyers is students who graduate and go out on their own right away. And sometimes that's choice, sometimes that's economic necessity. But for whatever reason, what would you say to a third-year law student who comes to you and says, I'm going to start my own practice right out of the box?
I would say there's some enormous challenges in doing that, but it's also, it can be done and you can be very, very successful. I mean, I have dear friends who, at least, you know, one dear friend who hung his shingle doing criminal defense work in Atlanta right out of law school, and now he's, you know, he's doing very well. Now, he'd have to tell you if it was a feast or famine, and, you know, if initially it was very difficult for him. But I think you're the best judge of your personal situation. I would say if you're going to hang your shingle, you better count on 3 to 6 months of not having a whole lot of income until, and you know, you get your name out there, till you get your experience. But it can be done. I mean, you're still going to have lawyers who, when you get your name in the public eye, or you're a member of the bar, who, one, you know, remembered being there and will refer cases to you. Two, if you're in an area that they don't want to practice in, they'll refer them to you. But you know, I certainly think there's some challenges to just leaving law school and hanging your shingle. Because one, it can happen. I think even then you're going to have to find those connections, other lawyers. You're going to have to find the mentors, the folks who will help you. Because as we said, you know, law school's great. In my opinion, it teaches you to think like a lawyer. But you're still going to have those connections that teach you to practice law.
Well, and Georgia has a mandatory mentoring program for every new member of the Georgia Bar, and but it's not a perfect substitute for what we've been talking about, but it is out there, even for people doing the solo practice. A lot of this coursework, most of this course is about professionalism, which, you know, means different things to different people, but they're operating with a very, you know, particular definition of what that means. Have you encountered over the last 12 years any issues that you would describe as issues of professionalism, lawyers trying to take advantage of you as a young lawyer, or lawyers misbehaving, or anything else that you would consider to be such an issue?
Absolutely. Probably all the things you described. I mean, I've encountered lawyers who, you know, who feel like you must take on the anxieties and dislike that your client exhibits toward the opposition. Quite frankly, I'll tell you, in my opinion, the opposite ought to be true of you. And I often will tell clients, you know, look, what I bring to the table in part for you is my objectivity. And so I'm not going to take on your dislike of, you know, let's say a contested estate matter where siblings just absolutely hate each other and they're fighting about an estate. You know, there's lots of layers of the reasons why you probably could go back and unpack the hatred between them.
Well, Mom liked one of them best.
Right. I mean, you know, it's countless reasons as to why that is. But, you know, what you bring, and I think it is an issue of professionalism, is the ability to pull back from that and objectively advise your client. Now, I think any good lawyer and litigator is not going to be blind to those factors. I mean, because those factors can also come into play in how the case gets resolved. And look, sometimes you're going to have those layers of discord between opposing sides that are well justified. I mean, so there's certainly times as a lawyer that I see my client's dislike for the opposition, and I understand that it's a result of having been done wrong, literally, truly. So I can share my client's desire to right the wrong, but I do think it's important as a professional to understand that you're a counselor as well. And,
you know, this is interesting because this is one of the sources, I think, prime sources of lawyer misbehavior is, you know, preening for the client. And the client that comes in and thinks, I want a pit bull.
Right.
You know, I want somebody to, you know, get in there and misbehave on my behalf. You encounter those folks, I assume, at least at first.
Sure.
All right. How do you talk them down? And have you ever failed in talking them down? They walked on, wouldn't found themselves a pit bull.
Yeah, I mean, I understand as a lawyer, you've got the right, subject to not putting your client in a position that's going to jeopardize their interests. You got a right to get rid of a client just like they have a right to get rid of you. And, you know, so if a client's asking you to take a position, and again, don't misunderstand me though, you're still there to be a zealous advocate, okay? And so within the bounds of ethics, within the bounds of the law as applicable to the case, I mean, I'll be as aggressive as the next person. And I mean, there are those cases where clearly your client's been done wrong, there's no question about it. And sure, I have no problem righting that wrong. That's one thing we're hired to do. But yeah, you're going to encounter those clients who say, well, I know you think we ought to do this, but I want you to, you know, I want you to take it in this way. Now, the easy ones are the ones that they want you to do something illegal or unethical, in my opinion, because it's no. And I've told clients, look, my law degree is worth a whole lot more to me than it is to you, and so I'm not going to do that. If you want to take that course, then, you know, I'll give you a list of lawyers who you might want to consult.
Yeah, I had one. Speaking of reputation, I had one that wanted to have a bonfire with documents of the civil case. So,
and you have, I mean, you have clients ask you that, you know, okay, do we really have to produce that document? You know, well, yeah, we do. I mean, there's no applicable privilege. There's no, it's a discovery request that clearly asks for the document. I mean, so you're going to have those lines where you have to still, I mean, you're the one that's guiding your client. And your client, one thing your client, I think, is owed by you is solid advice on what the right thing to do is. I mean, that's what's so cool about law practice. I mean, you're also going to have chances to, you know, the law is one thing, but you're going to have chances to tell individuals, look, the law lets you do this. Do you want to resolve this dispute? Then, hey, you don't have to do it, but if you approach the problem this way, then you're going to be able to arrive at a resolution. You're going to be able to arrive at a resolution that's much less costly to you, emotionally, financially.
yeah, I often tell students that they learn in law school, you know, what they can do, and lawyers have to decide what you should do.
That's right.
And that's a much harder question. Well, that's maybe the part of the client side of this professionalism issue. But you know, my old boss used to say that practice law would be great if it wasn't for clients, judges, and other lawyers. Let's talk about other lawyers. Have you encountered conduct from other lawyers that, as you came out of law school, surprised you, dismayed you, and how did you handle it?
I have. You know, as a young lawyer, you're going to encounter a variety of different lawyers. And, you know, some lawyers are going to know you're brand new, and they're going to try to take advantage of your newness. One way I think you combat that is to outthink them and outstudy them and understand that, you know, we talked about mentors earlier, too. That's a good example of where you know, it's good to have a more seasoned attorney that you can say, you know, hey, this lawyer over here is saying I need to do X or pushing on me this way. And a good mentor would say, oh, I'll just stick to your guns. You know, he's just trying to push you around. And I had that. I mean, I recall, you know, early in my practice taking a deposition. And look, I mean, a discovery deposition's wide open. You can ask just about anything. But he didn't like my questions, so he knew I was a brand new lawyer, and he was just giving me a fit. You know, oh, you can't ask that. And thankfully, I'd had the background where I was like, well, this is a discovery deposition. I can ask anything I want to practically. So, you know, that's But you're also going to encounter lawyers who are just difficult and whose whole practice is not to look at the law, but to just be as difficult as possible. I think some lawyers equate that with zealous advocacy. And I mean, every issue, just fight about discovery extensions, fight about when you schedule a deposition, fight
where,
about
or where to schedule it.
where you schedule it, who goes first, even when you get to the deposition, objecting to every question. I mean, you're going to encounter difficult lawyers just like you encounter difficult people in life. But in my experience, usually those individuals who push at every level like that are usually not the most effective lawyers. They very quickly develop a reputation in the bar, and this is a profession that is very connected, and so. But you're going to run into those folks.
The good news, I suppose, about the clients and then the lawyers is most clients are going to trust you and take your advice to handle it the way you think they should. And most lawyers are going to be, you're able to get along with them.
There's
right?
no question.
Right.
I mean,
there are those clients and those lawyers,
right.
But for the most part.
But the majority, it's a pleasure to practice with other lawyers, and you can feel, even clients that you're not, quote, successful in resolving their case in the way they would like, your clients will know if you gave their case the attention and gave them the attention that they deserve. So,
one issue that's come up in our discussions over the course of the semester is the circumstance where the lawyer on the other side isn't doing a very good job. All right, makes a mistake, or just generally isn't doing it the way you would do it. Of course, as a litigator, you're competitive. You already described yourself that way. You're in a position to take advantage of that to your client's benefit and to his or her client's detriment. How do you feel about that? Does that happen to you?
it does, absolutely. In fact, we had a high-stakes case where the other side defaulted and resulted in a multi-million-dollar judgment against their client. And those lawyers really took us to task and said we had an ethical obligation to tell their lawyers before we took the default judgment. I think there's a line between being a zealous advocate and representing the interest of your clients. And quite frankly, I think you run afoul of your own duties to your client if you let this sense of, well, I need to let the other side know. But there are times as well where if it's not going to benefit your client, you don't need to take advantage of every single thing another lawyer does that's not in line with how you would have approached it. And I'll give you an example early in my practice where a lawyer, you have to be diligent. If you file a lawsuit right at the statute of limitations, you have to be extraordinarily diligent to serve that, or it's going to subject the lawsuit to dismissal. And so as a young lawyer, crossing my T's and dotting my I's, I said, oh, I can file a motion to dismiss this lawsuit because this other lawyer on the other side was not extraordinarily diligent in serving this lawsuit. So I hauled off and filed a motion to dismiss, which quite frankly on the public docket and certainly in the eyes of my opposition's client made him look very bad.
Made the lawyer look bad.
Made the lawyer look bad. What I learned though was that under the law in Georgia he could certainly save his problem. You had to serve it and then timely dismiss it, refile it, and timely serve it the second time. So a little more experience, what I learned in that, I mean, and that lawyer was not happy at all with me. But I learned that, well, the law allows him to solve his problem. So perhaps professionalism, a better way to have handled that without jeopardizing my client's interest would have been to call the other lawyer and say, look, you weren't diligent in service, I can file a motion to dismiss against you, but if you'll stipulate that you've burned the dismissal, then we don't have to make you look bad. Now, I think you got to be careful because you can't let your you don't have any obligation, but you can't let your sense of not wanting to make another lawyer look bad jeopardize your own client's interest. And that's why I think if faced with that same situation today, I would, because I'm not jeopardizing my client's interest, I would say, look, I plan to file a motion to dismiss against you, but if you'll stipulate you've burned the dismissal, I've accomplished everything I could have for my client, and I've been professional, not made you look bad.
Well, of course, one of the tenets of professionalism is civility, and we've talked about that a lot this semester, but there's a limit to civility, right? I mean, if your client's legitimate interests really are sacrificed, I mean, you're not going to let civility, you know, just getting along with the other lawyer get in the way.
Yeah, I mean, you're clearly a fiduciary for your client, and you're right. I mean, civility should never allow you to jeopardize your client's interest. I mean, you're going to encounter times when, man, you've got that other lawyer over a barrel, and you know you're wearing them out pretty good. But you know, I'm sorry, that's, you know, you filed the lawsuit, or you took a position that wasn't merited, and you know, I hate to do that to you, but that's what it is.
I mentioned already, you mentioned that you have a large family. Congratulations on the adoption of your 6th child recently. How on earth do you do that? Given the demands of practicing law, we all know it's a very demanding day.
Right.
But I know you're committed to your family and to making sure that you do that right. How do you do it?
Well, first you find a remarkable spouse.
Let me write that down. I already did that.
Daisy's noting that. So, you do. But you know, I mean, I love what I do. I love law practice. But my law practice is not an end in and of itself. Equally fulfilling for me is being a father and plugged in with my family. So, some context for y'all. We have 5 daughters. My wife and I. We had a 5-year-old daughter, a 4-year-old daughter. We found out we were expecting our 3rd, we thought, and our 3rd turned out to be our 3rd, 4th, and 5th. We had triplets, so all little girls, and which was remarkable. I mean, I can't talk about my daughters without smiling, but you know, they're wonderful. But my wife and I then said our family still we didn't feel was complete. So in January we adopted a little boy, and so TJ is home with us now. But anyway, I mean, I think it's easy to, you have to, much like you all have to in law school, I mean, you've got to carve out time to get the tasks that you need to accomplish accomplished. And if law school is good preparation for practice, it is in lots of levels. One thing, at least for me, it was good practice, preparation for practice, is dealing with this gnawing sense in the back of your mind that there's always more you should be doing, there's always more you could be doing. But you know, one of my law professors said, you know, what's going to make you the most effective lawyer, though, is to realize that there are limits to the law and take time away from the law. And you know, my family certainly serves that in part for me. Is, you know, what I do, I work hard, I want to be well respected, I want to be successful financially, you know, I want to continue to have cases, but part of the fulfillment in that is knowing that in turn by doing so I'm providing for my wife and I'm providing for my children. So it's time management. I know you'll hear that. I mean, oh, that's time management, but what do you do when you're just covered up? You also, you know, you have to have family who understand the constraints, and you have to, you know, Valentine's Day this year, we had big plans for a dinner with all the family, and, you know, I got a call from the jail. Somebody got arrested, and I had to, you know, go help get that person a bond. So your family understands. I mean, they're along for the ride with you. But it's a matter of carving out time and understanding, you know, when you, litigation particularly, it's a peaks and valleys type. There'll be times when I am going to work all weekend. If I've got a trial, I'm going to work 2 weeks straight. And my children know that and understand that. My wife knows and understands that. So,
and it takes some real planning to try to.
It does, but you know, you hope you've got it planned out.
Well, in just a couple minutes, I'm going to turn this over to the students and let them ask anything they want to ask. But I try to remember, although I forgot it with Judge Sizemore, but he reminded me. I try to remember at the end or at this stage of these always to ask this question, and that is, you have a captive audience here, first-year students. You have a perspective that they don't, and I want to just invite you if there's anything you want to say to them, anything you wish somebody had said to you when you were sitting, the first year class at the University of Georgia, what would it be? Well,
you know, and you may have heard this from others, remember why you came to law school, but, you know, remember the passions that drove you to come here in the first place. You're all, I expect, very driven. You're all obviously very smart people. But understand, you know, even, quite frankly, if you haven't done as well as you wanted to in first year, I mean, in my experience, everybody came in the first year thinking you were going to be top of the class. You know, that's just the kind of driven people you are. But, you know, law is a wonderfully rewarding profession. And understand that, you know, you're going to develop as a human being just like you are getting your legs under you in the law. And my career is probably a great example of, you know, your first job is not necessarily going to cast you in a mold that's going to be you for the rest of your career. Don't lose sight of what you're interested in. Don't lose sight of, and leave yourself open to become interested in other things. Like I said, my own development of a real passion about criminal defense was not anything, had you asked me in first year law school, I would have thought about. But your life experiences are going to mold you, and be open to that. I mean, it's easy for me to say, but be open to making changes. Don't feel like, don't stay somewhere you're miserable. I mean, you're not going to do well at it. I mean, what's the, you know, find a job you love, you'll never work a day in your life. I mean, and if you're not doing something you love, now your circumstances may be such that you do have to stay there for some time, but make an exit plan. Understand that, you know, what you bring to the table is your desire to help people, your intelligence of you know, helping people in very difficult situations, or helping people negotiate a business deal if you're going to be a transactional lawyer. But you know, remember why you chose the law. And look, you know, the other thing is, if it makes you miserable, then don't practice law. Do something else. I mean, a law degree is a phenomenal background no matter what you choose to do. And I had, you know, law school. I would not have personally done that. You know, I think law school is way too rigorous to get out and not practice law. But you know, do what you enjoy.
We turn it to the students. What questions do you all have? Yeah.
I was wondering first, at any given time, how many open case files you have, and secondly, I was wondering how many staff members you employ and what they do.
Okay. For the benefit of the recording, I'm going to repeat the question. There's two questions. One, at any given time, how many case files do you have open, and how much help do you have?
All right. Well, I have probably 35 to 50 files open at any given time currently. As a federal defender, I had probably 90 open at any given time. But the variety of the litigation I do, they're very manageable because, I mean, every case is not going to be as time intensive as the other. I mean, some routine collection matter may not require much time at all, or there could be some long-standing litigation case that's going to, you know, be 3 years. But, you know, 35 to 50 currently. And then staff, what I chose to do when I opened my own practice was to share overhead with another lawyer. We have our own firms, but we share an assistant, and that's it. Now, I subcontract out some paralegal work as I need to, but that's the only staff I have currently, myself and a part-time assistant, part-time to me.
Yes, right here.
He asked less questions. You can go ahead.
We got time for both of them. Go ahead.
Do you still plan to continue indigent work, and what kind of challenges does indigent work present for a startup solo practitioner?
All right. Do you still plan to continue doing indigent work, and what challenges does that present?
Absolutely. I have always done appointed indigent criminal work, so I have consistently, when I went back to Jones, Cork and Miller from the Federal Defender's Office, and consistent through my current practice, I take appointed federal criminal cases. In all candor now, even appointed federal criminal cases do pay, but I have always taken appointed cases. And part of that, part of it's a business issue because I think it's important to stay in the federal courts and to be visible. I mean, that's advertising in and of itself, to be there. But the judges appoint you, so I've continued to take them and will always take appointed cases. Now, on a personal level, again, I haven't lost my desire to continue to provide, you know, a representation to those who otherwise couldn't afford it. So,
On a kind of like, you are in Macon and not Atlanta, so I guess you would across an attorney more than one time in your career possibly? Or,
yeah.
and if you do that on a constant basis with somebody, do you ever get like an arch nemesis status with them, or like they just want to?
No, I'm a likable guy. So,
The arch nemesis question, we've not gotten that one before.
You certainly are going to run into lawyers who you see their name on the pleadings and you're like, oh, great. You know, this case is going to be. I mean, you're going to run into lawyers too. You're like, you see their name on the pleadings and it's like, there's no cutting corners here. I mean, they're going to hold your feet to the fire and you're going to have to. But it's a whole lot easier to practice law against good lawyers. But yes, and you know, the Macon bar is very small, and I will tell all of them, you know, be aware of your reputations. You know, Atlanta is, it may be different. I've never practiced in Atlanta, so I probably shouldn't say about Atlanta. But in everywhere else in the state of Georgia, you need to be aware that, you know, the things you do, I mean, people are going to remember. If you try to take advantage where you shouldn't, or if you cut corners, or if you're unethical, you're going to have a hard fight to regain that. And even at the level of just being difficult to deal with. I mean, there are lawyers who have matured here in Macon, but who, when I started out, the other lawyers would say, oh man, he's terrible to deal with, or she's terrible to deal with, she's difficult about everything, and you can't trust what they say, you know. But by and large, like in my experience practicing here, it's just a pleasure because, you know, our words are bond, and other lawyers know that. And if I tell a lawyer I'm going to do something, again, as long as I haven't jeopardized my client's interest. I mean, you need to think about it up front, okay? I mean, you need to make commitments that you can live with. And stand by your commitments. But yeah, I mean, you're going to run into difficult lawyers in Macon just like you do anywhere else.
Yes.
But arch nemesis, no. I mean, that's one thing I think the general public has difficulty understanding from the we lawyers. I can go against my best personal friends in the world who are lawyers, and I'm going to try to, in fact, I'll probably try to beat them. I'll be more determined to beat them in the case because that sense of competition. But I think sometimes the general public doesn't understand that, you know, we can go into court and battle it out and then leave and be close friends. But you're going to run into difficult people.
Yes.
Whether they're your nemesis depends on your personality, I think, really. So.
Judge Sizemore said he kept a list. A very short list.
Yeah, I don't keep a list.
So you can move up the list, you can move down the list, but you never move off the list. Yes, sir.
What are some areas of law that you've decided specifically that you're not going to take cases in, and why?
All right, what kind of cases will you not take and why?
I don't do divorce cases. I originally didn't do divorce, one, because I was in a firm that didn't handle divorce. I don't do divorce cases now. I've always rationalized it because they're too contentious and time-consuming, and no winners, no clear-cut winners. But I do contested estate fights, and those are just as nasty as divorce. So, and there's other areas I don't practice in just because I'm not. I've never practiced in them, and I'm not competent in those areas. What I think you'll all come to realize, or I hope for you, that you're going to develop practice areas that match your personal interest. And then, quite frankly, as long as you're able to stay busy in those interests, then that's going to dictate what you choose to practice in. I mean, so there are other areas of litigation that I would practice in if I had to from a business perspective, that I certainly could gain, you know, a working knowledge of the area in. But right now I'm just very fortunate that the things I've described to all of you, criminal defense work and plaintiff's personal injury and those outliers that are like business type litigation, that's enough. I'm a solo guy, that's enough to keep me busy, and so I don't have to develop those other practices.
Other questions? Yes, sir.
When you started off your solo practice, did you take out like a small business loan to meet like payroll obligations and get your stuff up? And how did you meet your financial obligations until your firm was profitable, I guess?
How'd you finance the startup?
Well, I was very fortunate. I didn't have to take out any loan. Well, my parents did help on some startup capital, I will say, okay? But as I mentioned at the outset, you know, the great thing about being a lawyer is you're the economic engine. I mean, your work, be it hourly or on a contingency basis, you don't have to have a lot of overhead. But the things, you know, I bought a laptop computer, I bought a desk, I rent my space where I'm at. So my overhead actually is very small, and it was small enough that I didn't have to take a loan out. I did, for my own comfort, not that I had to draw on it, I did get a line of credit with a bank, but that was more because I was worried, like you said, I was worried about cash flow early. I knew I had clients. I knew that, well, because I knew I had certain hourly clients who were coming with me, I knew with pretty much surety that 60 days in, I was going to have cash flow, okay? And so that was the period I particularly was worried about. And I was also, so I wanted that equity line, not equity line, the line of credit, because you're going to have expenses, you're going to have deposition costs, you're going to have travel expenses, etc. But I also, with full disclosure to the firm I was departing from, I had certain cases that I knew were going to resolve not long after I left. Okay, now that sounds, but again, that's an ethical issue. You deal with your former firm, and everybody knew, you know, what cases were mine, and we worked out, you know, splits with the former firm. But you know, you got to take your own individual scenario and be realistic about your cash flow. But if you can go without a paycheck for 60 days, then you can be a lot more realistic about your cash flow and just generate the work, and then you're going to start having AR, accounts receivable due.
Time for one more. Yes, sir.
I have a quick, you have a large family. Do you think, and I was trying to do the math in my head based on, you said your oldest daughter 5 years old?
No,
Or she was?
they're now 10, 9, the triplets are 5.
So you started your family while you were still getting on your feet as a young lawyer.
Right.
How did you deal with that? We've heard a lot about how, especially in larger firms, there's a lot of pressure put on associates to do a lot of work. So how did you balance your family life as a young lawyer?
How did you balance family life as a young associate?
Well, let me tell you too.
You've got 1 minute to answer that question.
You can't typecast larger firms either. Jones, Cork & Miller is a wonderful firm from a family perspective. I mean, yes, you had the pressure to have billable hours, and you had the pressure to do well financially for the firm. But one, you find if you want to be in a larger firm, find a larger firm that still values family life. And quite frankly, you know, you're in a political environment where that's the cool thing for some large firms too. But I never had a problem. I mean, I always found jobs and placements where the folks' interests there aligned with mine, even down to the level of family. So.
Brian, if you can stick around for a couple of minutes, there may be some students who want to meet you individually. But meanwhile, thank you for being with us.